All right, I think we're going to go ahead and get started. Thank you again for being here. My name is Caitlin Reese, and I am the co-chair of Balancing the Scales of Justice. We are a task force that was created by Bishop Barker and the Episcopal Diocese of Nebraska to respond and create faithful witnesses in support of criminal justice reform. So we are really grateful for the opportunity to partner with groups like ACLU Nebraska, Civic Nebraska, and Community Justice Center on this discussion and on broader efforts that we've been working together on regarding voting rights restoration for returning citizens. So some of you all were with me last year. We partnered with some of those same partners to do a letter to the editor workshop focused on voting rights restoration as one of the key policy areas that we need reform in the criminal justice system in Nebraska. And I'm grateful. I see this as kind of a continuation of those efforts. So thank you again for all of those partnerships. I'm going to turn it over now to Shakur, who's going to share a little bit about his personal experience navigating voting and what he's heard from other returning citizens.
Yeah, so I am Shakur Abdullah with the Community Justice Center, also a returned citizen. My path started nearly 6 years ago. I was released from a very lengthy incarceration in 2016. So as most of you know or should know, there's a 2-year waiting period after that sentence ends. I was actually discharged. So my 2-year clock started the day that I was released. Wasn't able to vote until 2 years after my discharge. For me, it was kind of a double barrier because I was incarcerated at an age too young to vote. Yet when I was released, I was old enough to vote and yet still not able to for another 2 years. So it really kind of just presented itself as an artificial, unnecessary barrier to a much more fuller exercise of citizenship. I was allowed to do everything else. At the top of that list was pay taxes. So, that was something I thought was a little strange. If my tax money was good enough to take, I would like to think that my vote should be too. My head was counted for every census, yet I was never ever allowed to participate in the process. So for me, it just begins to be one of those other unnecessary barriers to reintegrate citizens back into the society after they have paid their debt. I think that is kind of the key thing here. Once the incarceration debt has been paid, you should be able to be fully engaged in citizenship in every single aspect. Voting is one of those areas that prevents that from happening. And I think the issue of citizenship is, ultimately the cornerstone of this argument. People have to realize that citizenship is not lost as a consequence of a felony conviction. And, when you begin to look at other societies around the world that take a much more restorative justice approach to reintegration of people that have done harm in their societies, they generally don't lose their right to vote even while incarcerated. It's part of that process of, yes, holding a person accountable for the harm that they have done, but not to ostracize them, not to marginalize them, not to make them feel as though, that harm that they did in the society is going to be something that is going to last forever. It should not. And even, I have a few friends that were released from prison before I was. They are still on parole. There's one individual that has been out for like 15 years. he's been out on parole. He has bought homes, cars, retired from his job. Yet he still has 2 more years to do on parole before he is done with parole. And for him, that 2-year time clock won't begin to tick until then. So when it's even viewed from that aspect, I mean, the absence of the ability to vote begins to be even more pernicious. So, that has been my experience and the experience of many other of my friends. And I just think that the 2-year waiting period in the state of Nebraska is not necessary. In 2005, the law was changed. It used to be a lifetime ban in Nebraska. You were banned forever from voting. And many people think that the 2 years is reasonable. I do not believe that it's reasonable. Like I say, in every other aspect, a person is still a citizen, and part of citizenship is that ability to be able to vote. So for me, I think that is the main reason why the 2-year waiting period should be done away with.
Thank you so much, Shakur. I really appreciate that. And we have several I should have said this up front. We have several speakers today, including Shakur, and we're going to open it up for questions here in a little bit. So make sure to hold on to your questions because we'll have time for a question and answer. I want to next, and Shakur talked a little bit about this, and I want to spend a little time now talking about the history of Nebraska's law, how it compares to other states, and kind of the history of disenfranchisement in general. And that will be with John from Civic Nebraska.
Hi, thanks for the introduction. I'll start my video here for a second so you can see what it looks like. I'm John Cartier, I'm Director of Voting Rights. I work in voting rights capacity full-time and do things such as get out the vote and election protection program, which is where we deploy a couple hundred poll observers throughout the state to make sure elections are running smoothly. So elections is kind of been my expertise, and I'll talk a little bit about the felony disenfranchisement law in Nebraska, but really how it interacts with it on a national scale in the United States and where its origins are from. So without further ado, Spike, did you have those slides by chance?
Yeah, I'll start doing it now. I think everyone can see the screen. Is that right? I think I shared it again. Okay.
That says ACLU Nebraska on it.
Yeah, sorry. This part's for John, for the viewers. I misunderstood because I thought, so I prepared these, but John's going to cover the first part of it. So,
awesome. Thank you. Okay, so originally the Nebraska Constitution basically implanted disenfranchisement right into its heart because at first they were trying to limit the right to vote to just white males in the original text. But as we'll go over here in a second, when they submitted to become a state, federal prohibition against that type of discrimination made it, they had to get a little more clever about how they're going to deny people that were not white males at that time the right to vote. And you see the text right there. Originally, this said, no person shall be qualified to vote who is non-compos mentis or who has been convicted of treason or felony under the laws of the state or of the United States unless restored to civil rights. And this is primarily how the text reads today, except we have a little bit of a difference with a law that changed that allows the 2-year waiting period. So it's not a complete lifetime ban. Next slide, Spike. And when we look at the history of felony disenfranchisement in the original 13 colonies, this was not a thing. It largely was a response after Civil War, and we'll get to that in a second. But as you see there, early colonial laws limited the penalty of disenfranchisement to just offensive related to voting or violations of the moral code. There wasn't designation of felonies at that time. Right, like I said, right after the Civil War, 29 states implemented felony disenfranchisement laws. And you can move to the next slide, Spike. And the reason was this: right after the Civil War and emancipation and the granting of Black males the right to vote, they started getting involved in the process. They were registering to vote. They were winning local elections. Eventually got the first Black congressman, and that really scared the white establishment, particularly in the South, but the North was guilty of this too. And so in order for them to try and restrict the right to vote that fit within the color of the law is how they characterized it. They passed felony disenfranchisement laws, often as amendments into state constitutions. And the reason they did this, they figured, well, we'll just construct laws in such a way where it will specifically, like a surgeon's knife, target African Americans and other minorities and leave, for the most part, white poor people alone. But even then, they weren't too concerned about white poor people losing the right to vote. You can move the next slide. So Southern states really took the lead in this. Mississippi was basically one of the first ones to adopt disenfranchisement laws such as this, along with a litany of other ones such as understanding clauses, literacy tests, poll taxes, lots of really just nasty stuff. This is commonly referred to as the Jim Crow era. Yeah, perfect. So here's an example in Alabama. This was one of the presiding officers over their state constitutional convention, which its purpose was to amend its state constitution to implement all these really nasty voter restriction measures. And they really just stated what the purpose was. We can go back and this is in Nebraska too, but you see what the specific intent of these legislators was to cut out of the electoral process African Americans because they believed it was just something that could not happen. And the language is just nasty, the menace of the Negro domination. And like I said, this was just a response to them, African Americans, starting to get organized, getting elected, and being a really effective voting bloc. As a result of a lot of these disenfranchisement measures, the statistic is in Alabama, it was about 100,000 African Americans were registered to vote around 1895. After about 10 years of disenfranchisement practices, including felony disenfranchisement, it cut the voter participation rate by 99%. And it's not exaggeration. It was about 1,000 people were left standing after all the bad disenfranchisement laws. In Nebraska, Congress passed the Enabling Act 1864. This was what got a lot of the Western states organized and implemented. And it specifically provided that the territory of Nebraska was authorized to form themselves a constitution, a state government. And the federal act also gave out specific criteria that the state constitutions would need to follow. The initial effort to create the Nebraska Constitution was unsuccessful. We don't necessarily need to go through all that history. So in order to get over the Democratic opposition to what was preventing them from becoming a state, they provided that the right to vote was limited to white citizens of the United States or white persons of foreign-born birth who shall have declared their intention to become a citizen. And this explicitly limited the right to vote to white men. And this was in conflict with federal requirements for accepting a state to become a recognized state under the Constitution. So it was vetoed, and they came to an agreement on an amendment that conditioned statehood on acceptance of a prohibition on voting restrictions based on race or color. President Johnson here vetoed it, but Congress was able to override it. So eventually the Nebraska territory was accepted in 1867, and in kind of a very pity move, the territorial legislature adopted a resolution that says they're still in favor of suffrage to just white males, but that had no effect. So on March 1st, 1867, Nebraska then became a state finally. And then this cues into the eventual fusion of the various constitutions with felony disenfranchisement laws. this is where inside our own Constitution, we saw in slide number 1 what the felony disenfranchisement was, and that was just limiting anyone who's convicted of a felony. And again, the strategy was they would construct laws in very specific ways that would very, like a surgeon, target African Americans through a litany of unfair criminal charges because it would punish them versus, a similar charge against white people or poor white people in an area. You can go ahead and skip this one. And felonies, some of the examples are theft over $1,500 now, simple possession of a controlled substance like marijuana, and enhanced misdemeanors. And I'll editorialize this a little bit here, and I could pass it off to you, Spike. What happened next in the battle here in 2004, there was a group of senators who introduced a bill that would completely remove the prohibition on voting rights as a result of a felony. This was a push of a national, or a result of a national push to get rid of a lot of these racist laws that were kind of hallmarks of the Jim Crow area. And they were very dangerously close to getting that, but they had to come to a compromise at 2-year waiting period before it was going to get enough votes to pass the legislature. And, I think Spike will go into this, but that number is completely arbitrary. I think the compromise was, okay, well, we want 0 years. And then the other side's, well, how about 5 years? So they came to the 2-year waiting period. And based on our research of this area, laws such as this increase recidivism rates more than they probably help. And the reason is because the more you can incorporate people back into society after they serve their sentence, the more likely they'll feel, like they're part of the community. Then part of their right to vote is a part of that. And with the right to vote and feeling part of the community, they're less likely to reoffend and get felonies. And there's some research to support that these laws on the books currently goes against that line of thinking. So, every year we've introduced bills that would get rid of the 2-year waiting period. We actually successfully in 2017 passed a bill that would get rid of the 2-year waiting period, but unfortunately Governor Ricketts vetoed it. And that was the year he got veto overridden on DACA and death penalty. So I think some of his conservative legislators didn't want to defy him a third time because really concerned about the type of money he'd be able to throw at any opposition to his seats. And that's the overall history for felon disenfranchisement in Nebraska, as well as the national landscape. And really where it comes from is white people wanting to continue domination after the Civil War and trying to restrict the right to vote. Thanks for listening.
Do you want me just to start then?
That'd be great.
Okay, thanks. Okay, I'm sorry about the shared screens and the shared PowerPoint. My name is Spike Eichler for the ACLU. I just want to pick up where John left off to talk about the current law. John was right, and I think also Shakur mentioned this before, but in 2000, either 4 or 5, I can't recall, it was my last year of actually working at the legislature, is when the state legislature eliminated the lifetime ban and put a 2-year waiting period, if you will, for restoration of the right to vote. And that compromise was just that. It was a scrum on the floor of the legislature. Some people were opposed to removing it at all. Some people suggested a 5-year ban. Some people proposed to have like different waiting periods depending on the type of sentence that was imposed with a felony. And eventually, I remember my boss, Kermit Brashear, with Diana Shimmick and Ernie and Doug Christensen underneath the balcony, and they just came up with a 2-year compromise. Okay, so it's arbitrary. And I wanted to kind of talk about sort of the arbitrariness and the irrationality, if you will, of why we even have the loss of the right to vote because you're convicted of a felony. The origins were explicit, particularly in the southern states, that this was a way to disenfranchise newly freed people, people of color, Black people, that they were too influential politically, and the white minorities in some parts of these states wanted to silence them. And they kind of took this concept that existed in some of the earlier colonial states of losing your right to vote if you're convicted of certain crimes, and they expanded it to felonies. That, people commonly, you stop someone on the street, say, hey, should convicted felons be allowed to vote? And there's kind of a certain, I don't know, resonance among many people that makes sense, right? That people convicted of a felony, probably kind of a bad thing they did, they shouldn't be right to vote. But I just want to remind everybody, and this is an argument you can make when you're making this argument against this prohibition, is that a felony is just whatever the legislature says is a felony. And it's not a violent crime necessarily. It's not a serious crime in some respects. And it's not even what other states regard as felonies. And I'll just give a couple of examples. A felony conviction results in the loss of right to vote, any felony, and it can be a bad check for over $1,500. It can be possession of a residual amount of methamphetamine, cocaine, heroin, or even some of the pills that you need prescriptions for. It can be enhanced misdemeanor, so driving during suspension, second or third offense, driving under the influence. All these things that have absolutely no nexus to your right to vote. And I wanted to kind of juxtapose that with this. There's a series of crimes that are in our statutes, and I only listed some of them, that say that if you falsify a ballot, or if you misrepresent your party affiliation when you vote, or if you falsely do something in the process of voting. I'm not in favor of people losing their right to vote if they do any of these crimes, but at least if you're going to have a criminal law that removes a person's ability to vote, it ought to have some nexus with the act of voting. But oddly, if you look at some of the, and this is just some of the crimes, you can look in chapter 32 yourself, which is our election laws, you can do some pretty nefarious things with your ballot, or if you're a registrar or someone in charge of elections, and you're convicted of simply a misdemeanor. In other words, you don't lose your right to vote. You can be somebody caught with somebody else's pain pills, lose your right to vote, but you can go in there and say you're a Democrat and actually vote in a Republican primary, or vice versa, and you can vote next time around like nothing has happened once you pay your fine and you do whatever you have to do on that misdemeanor conviction. As far as numbers, there's about 7,800 people each year who are restricted from, I gotta move my screen here, from voting because of felony convictions. Because a felony conviction is part of the criminal justice system, and if anyone ever looks at that subject, the criminal justice system disproportionately impacts poor people and people of color. People of color are overrepresented throughout the criminal justice system, not just for numbers of arrests, but on the level of charges, the severity of charges, the severity of conviction, and the length of sentences. So this has a clear racial impact against people of color, especially Black people. And I just want to do a couple of snapshots. This is a slide that I used on another thing I'm involved in, but just take a look at Lancaster County Jail on August 6, 2021. These are pretrial detainees. Most of them, 60% are felony pretrial detainees. The makeup for Lancaster County for Black people is 4.3%. Yes, in the jail is 31%. And you can see that white people make up 80%, but they're only making a little over half of the people in our jail. And similarly, at the end of the second quarter of 2021, even though Black people make up about 5% of the population in the state overall, they make between 1/4 and 1/3 of the people in our prison system at any one time. And the people in prison are people serving felony sentences. Shakur mentioned this earlier, that the law was changed in 2005 to allow for automatic restoration of your right to vote 2 years after completion of a sentence. A sentence can be various things. You can get a fine. Some of these drug charges, even if you're convicted of a felony, some of the judges around the state will just give you a fine. So the 2 years starts when you pay that fine. If you get 30 days jail for a felony, the 2 years starts when you get out of the jail. When you complete a prison sentence, that's when the sentence is done in some instances. When you jam your time, like Shakur mentioned, when he was released, that's when the 2 years started for him. If you get probation for a felony, the 2 years starts when you complete your term of probation. Or if you're on parole, it starts when 2 years after completion of parole. And then there's a new sentence that was passed in LD 605, post-release supervision, which is a type of probation, maybe kind of a type of parole. It's 2 years after that. This is just arbitrary, and it's deliberately confusing. And this 2-year window, you can see how administratively it's difficult to calculate, because the Secretary of State ultimately sort of determines the voter rolls and eligibility to vote. But as far as this sanction for a felony conviction where you lose your right to vote, there's these different agencies that determine when the sentence is completed and therefore when the 2-year clock starts. And this is where you can see the administrative hassle and the layered government approach that we do in this society and the state can really break down. So which sentence or which agency determines completion? And I just listed those possible sentences before. If it's a payment of a fine, well, the clerk of Sheridan County Court determines whether you paid your fine, right? They figure out when the 2-year clock starts. Similarly, completion of jail, when the jail and the clerk of the court says you completed your time, well, that's when the 2-year clock starts. If you go to prison, the Department of Correctional Services figures that out. If it's probation, the probation department is within the Supreme Court administratively, so they determine the 2-year window. Parole is a board of parole, and post-release supervision, again, goes back to probation. All these different agencies, and particularly all these different counties, need to relate and work with the Secretary of State. And we know from our own work that the ACLU has done that can be confusing, be broke down. I think, and I didn't put anything in the slide on this, Sam can remind me, but we actually sort of did a question, like a randomized questions where we just called up clerks of the county court and election commissioners asking, when can somebody who's been found guilty of a felony vote? We had a whole bunch of answers. They had to get probation, it had to be successfully completed, or they had to have it set aside, or they have to have this and that. None of that stuff is accurate. It's 2 years after completion of a sentence. We had an example of something that we did last year where a number of people actually contacted the ACLU saying that they were past their 2 years, they were eligible to vote, but they were told they could not vote because they were a convicted felon. And we actually looked online and we did a Freedom of Information request, and the Secretary of State themselves were misadvising people that to be a felon and to be eligible to vote, you'd have to be 2 years after you successfully completed probation. I practice criminal law. There's nothing in the statute that defines or characterizes successful or unsuccessful completion of probation. You either complete probation or you have it revoked and get sentenced as if you never got probation. But the Secretary of State on their own website and letters to the different election commissioners were telling people, make sure, or telling officials, make sure that the person successfully completed probation and it's been 2 years from that. And so some people were actually, some eligible voters were improperly notified that they could not vote. So finally, we worked with Secretary Ebnen, and with our Freedom of Information request, we identified about 300 records that were suspicious. On his own volition, to his credit, Secretary of State corrected about 51 of them, and then sent corrected guidance to all the different county election officials on the correct understanding and application of the law. Other than sort of working on some legislation to sort of enhance the relationship between the different county agencies and the Secretary of State as far as calculating 2 years, what other kind of sort of remedies might be to sort of eliminate this arbitrary disenfranchisement? And the ACLU affiliates in other states have thought of a couple of ways to do that. And that is this: because felony prosecution, felony conviction in the criminal justice system, and therefore the loss of the right to vote, has such a disproportionate and disparate impact on voters of color. Maybe there's a claim of equal protection or some similar constitutional argument that you can make that our current state's 2-year waiting period disenfranchises people of color unfairly. That on its face, it might seem neutral, but in actuality, it's got an impact that's very disparate. Well, some other affiliates have tried it in a couple of states, and we've had mixed success. In Minnesota, ACLU lost at the felony level. Minnesota has some sort of a different version, and that is you have the right, you lose your right to vote until you do complete your sentence. But Minnesota is much better, if you will, to provide for probation and parole and supervised release than we do in our state. They don't incarcerate at the same high rate that we do. So our affiliate there made an argument that is, you've got people who are serving a lot of sentences, and arbitrarily they can't vote even though they are in the community, working, buying, paying taxes, doing productive things, they should be able to vote just like anyone else who's not on probation or parole or some similar thing. And significantly, even though they only make about 4% of the voting population, African Americans make about 20% of the felony convictions disenfranchised voters. So you lost the trial level, but they are on appeal now to the Supreme Court with some hope that it'll be reversed. And similarly, last year in North Carolina, the North Carolina Constitution, and this is one of those states that did something past post-Civil War, that a person convicted for voting unless a person has their rights restored. In 1973, they sort of provided for restoration of vote once they are sort of done with the sentence. But administratively, the state was denying voter registration to people who are still on probation or parole or post-release supervision. The Supreme Court in that state issued an order sort of telling the election officials in the fall of 2020 that they could not deny voter registration for people of color primarily, or people who were still on probation or parole. So there's some mixed success. There's some hope that maybe there's some legal remedy there, recourse, because it really is arbitrary. It really doesn't have any kind of sense, and since it has little rational purpose for the disenfranchisement law and the 2-year waiting period, and because it has such a disparate impact against people of color, we would submit that it's constitutionally suspect. So that's the current state that we have right now, the current status that we have right now. And I think that should, as my part, do I turn it over to, I'm gonna stop screen sharing. Do I turn it over to Caitlin then? Is that?
Yeah, thank you, Spike. I appreciate it. And I think, you know, every time I have an opportunity to partner with you all on events like this, I learn something new. And I really think your presentation this time highlighted how arbitrary the current law is. And whenever you draw a line that prevents people from a fundamental right like voting, you're going to have irregularities like the ones that you highlighted, where if we did not have a 2-year waiting period, there would be much less confusion. Because it's so arbitrary, there's a lot of confusion and a lot of room for human error, which I think we saw with that example with the Secretary of State. So I really appreciate that. I want to turn it over now for some questions from our participants, our attendees today.
So is someone in discussion with any senators about bringing legislation again this year? I mean, next year.
Spike, do you want to field that question for us?
Well, I hope Senator Wayne is still a senator next year. Senator Wayne's introduced, I think he actually introduced his bill and it's still pending in committee.
Spike,
That would eliminate the 2 years.
Can you give some context for that comment for people who don't follow the news?
Yeah, he applied to be a judge, and he applied to be a judge, which he'd be very good at. I'm not laughing about that, but I don't want to lose him. And the judgeship was just, the vacancy was just posted, and I think the interview process of the committee is like later this month, so he could very well be appointed, or the governor could appoint somebody by the end of the year. And then the governor would appoint his replacement. But to answer your question, I should know this off the top of my head, maybe John does as he listen, but there is a bill in government committee because Senator Wayne has introduced it at least once, if not twice, since the governor's veto was not overridden in 2017.
Yeah, there's 2 bills, one from Senator Kavanaugh, which would get rid of the 2-year waiting period and allow individuals who are currently in jails and prisons with felonies to be able to still vote. And then, Senator Wayne's is in government committee as well, technically. So, and it's tough with the government committee because it's a really, really partisan 4-4 split. So basically anything pro voting rights is going to get 4 no votes, and those are very hard ones to move on issues. But we don't give up, and we still keep hammering it every year. And eventually, I think we're going to get something that passes, and maybe with the new governor, especially, there won't be a need for veto overrides. So it's just a matter of waiting out the clock right now.
You know, this issue is not necessarily a voting rights issue. It certainly is, but it's something that John mentioned earlier, and Shakur said, this is really criminal justice reform. This is re-entry, basic re-entry into society, returning citizens' rights. The 2-year waiting period only, well, most hurts those people who want to vote, right? Who want to vote in that 2-year period, who want to get reintegrated with society. I mean, if you, again, there's another argument why it's so arbitrary. You can get out of the joint, you can get out of prison and not get rearrested, right? You can go back and live in your parents' basement and just not even go to work and get a bunch of misdemeanor convictions. And once the 2-year window goes by, you can go out and vote if you decide to get registered to vote. So I would argue that those people who want to vote during that 2 window, who are truly and actually disenfranchised, are those people who we should allow because they are trying to reintegrate, they're trying to re-enter society and be a contributing member to it. They want to exercise the right to be a part of this community. Simple as that. And that transcends just voting rights. That's just encouraging people who have served their time, welcoming them back into the community as if as any other member of the community.
My name's Cindy Glisman. I'm with the League of Women Voters. Absolutely, the law should be changed, number one. But in the meantime, isn't there a big educational factor here to educate the families and returning citizens too about this 2-year waiting period, and then get out this knowledge and to register those voters too? It seems like when we're in the community, a lot of people don't even know that returning citizens are eligible to vote after 2 years.
Yeah, no, that's a really good point. And for Civic Nebraska, we've been doing what's called re-entry fairs every year. And that's basically, think of like a career fair for individuals who are about to get out of the system. And we had a booth that would educate inmates who went by. And you're right, about 80% of them, I would say, had no idea. They thought it was a lifetime ban. So the education is so key, especially while they're still inside prison. I think that's probably like the easiest way to do it. And unfortunately, COVID delayed the reentry fairs a little bit, but they've started to do virtual ones, which we've also presented information. Coming up for 2022, we have plans to increase digital GeoTV ads that will feature that information. So I think there's a potential where like every frame we have or slide, we can always have something that displays that in text or other means for people that might have disability. So there's things in the works, and education is certainly very important, and anybody that can do it makes a huge difference.
Yeah.
Right, that's also one of the things that we continue to do at the Community Justice Center. We have a very big presence in the state in terms of the 2 largest county jails, Douglas County, Lancaster County, service all 12 probation districts and all 10 facilities operated by the Department of Corrections. So at every opportunity that we get to engage in or to engage with the disenfranchised population, we are constantly reminding them of the fact that when your sentence is up, whether it be parole, probation, supervised release, you have the right to vote. So we are constantly reiterating that.
Thank you. And we just had a question come in through the chat, which is great. That's another great way to, great place to pose your question. So the question is, does the complex multi-county, multi-agency oversight of this issue that Spike walked through mean that for some returning citizens that they're not automatically returned to voting eligibility at the completion of their sentences? Do people kind of get lost in the bureaucracy? I think is really what this question is getting at. Has the ACLU seen some of that in the work that they've done?
Well, we did last year, of course, right? And when we did the Freedom of Information request, where the Secretary of State themselves were for years, as far as we could tell, misadvising the local election officials and people that got on the website and asked about it. So that's true. I think there's also some sort of not necessarily a hidden, but there's another, because there's so much unfamiliarity with the court system anyway. And it is confusing for those people who are even involved in it. To give you an example, probation orders can be extended or reduced in length of time, right? So it's not necessarily 2 years when a person was sentenced to probation is when they got done. So even the courts can't always track that time very well. I think there's a lot of sort of self-fulfilling, not necessarily self-fulfilling, but not imposed even really, but sort of that people themselves thinking, wow, I was charged with a felony, I was only convicted of misdemeanor, I must not be eligible to vote, so I'm not going to bother registering. Or I didn't get probation on my felony conviction, and I heard somewhere or think somewhere that I'm not, so there's a lot of misunderstanding. And that's really good that the Community Justice Center is trying to educate people who are in the system that just because you're charged with a felony in jail, you can still vote. You're not convicted of anything yet, including a felony. And it's 2 years when you're done, and it's an automatic 2 years. So I think so. And I think that the different layer of the government just adds to the confusion. The opportunity for human error, willful and otherwise, is just there. And I think it just hurts. It just hurts people. Again, poor people and people of color. That's just the fact.
All right. Well, I want to thank Spike, Shakur, John, and Sam, and all of you for joining us today. I also, if you want to get more engaged on this issue, you have a couple different ways you can do that. Two of them are ongoing efforts. So we have resources that ACLU Nebraska has put together on writing letters to the editor. It's a great way to shape public opinion and make sure that the conversation continues both in these circles and in the wider community about why this law needs to change. And then there's also a link, they're both in the chat, on how to contact your officials. So I would recommend you start with the government committee, but then also reach out to your senator. And if they're on the government committee, double bonus, that's really helpful. And then I also wanted to invite all of you, Balancing the Scales of Justice is organizing an event called Sacred Rights. It's a vigil in support of voting rights restoration. We'll be at the west side of the state capitol on October 23rd, a week from Saturday. And we're going to begin if you would like to walk with us, we're going to begin at St. Paul's United Methodist Church at 12:30. Otherwise, you can meet us at the Capitol and join us you'll hear from Shakur and from others. And as we raise support and awareness of this important issue. So if you'd like more information about the vigil or how to join us, I'm going to put my email in the chat. Feel free to reach out to me and I'm happy to share details. Again, thank you so much for taking time out of your day, especially I know midweek can get a little hairy. So I really appreciate you spending the time with us. And thank you again to our speakers for making this time available. Take care and be well.
Thank you all. Thanks.